What if I told you that the United States Supreme Court, all 9 justices, not one dissenting vote, just issued a ruling that could fundamentally change how your retirement savings are protected? What if I told you that for years, possibly decades, your employer may have been quietly draining your 401k or pension with excessive fees, and you had almost no legal power to stop it? And what if the highest court in the land just handed you and every single American worker a powerful new weapon to fight back? Because that is exactly what just happened. On April 17th, 2025, in a landmark unanimous 9-0 decision, the United States Supreme Court ruled in a case that touches every single retirement plan in all 50 states. Whether you have a 401k, a 403b, a pension, or any employer-sponsored retirement plan, this ruling affects you directly. And the vast majority of the 150 million workers and retirees whose futures depend on these plans have heard nothing about it. Here's the most important question I want you sitting with as we go through this video. Do you actually know what's happening inside your retirement plan? Do you know how much you're paying in fees? Do you know whether the people managing your money are legally required to act in your best interest? Because after today, you're going to understand all of that. And you're going to understand why this Supreme Court ruling may be one of the most consequential things to happen to your retirement in a generation. Before we break this down completely, if this is your first time on this channel, welcome. We cover retirement, Social Security, and financial news that directly affects your money and your future. Hit that subscribe button right now and the notification bell so you never miss a video like this one. And if you have a spouse, a coworker, or a family member who has a 401k or a pension, please share this video with them immediately. What the Supreme Court just decided affects their money too. Now let's get into it. To understand why this ruling is so significant, you need to understand the case at the center of it. And it starts at one of the most prestigious universities in the United States. A group of employees at Cornell University looked at their retirement plan and noticed something deeply troubling. The university was paying massive fees to two of the biggest financial companies in the country, TIAA and Fidelity, for something called record-keeping services. Record-keeping is essentially the administrative work of maintaining your retirement account, tracking contributions, processing transactions, sending statements. It's important work, but it should not be extraordinarily expensive, and these employees believed Cornell was massively overpaying for it, essentially handing millions of dollars of workers' retirement money to these financial giants for services that could have been obtained far more cheaply elsewhere. So they did what the law allows. They filed a lawsuit. They argued that Cornell's plan managers had violated a federal law called ERISA, the Employee Retirement Income Security Act, by engaging in prohibited transactions that were not in the best interest of plan participants. And here's where the story gets complicated. The lower courts threw the case out. Why? Because under the existing legal standard, the employees weren't just required to prove that a prohibited transaction occurred, they were also required to prove right from the very beginning of the lawsuit that none of the legal exemptions protecting that transaction applied. In other words, they had to prove a negative before they could even get their day in court. That is an almost impossibly high bar to clear, especially when most of the evidence of what happened inside the plan's fee arrangements is held by the employer and financial companies, not the employees. How can workers prove what they never had access to in the first place? The case made its way to the United States Supreme Court, and on April 17th, 2025, every single justice agreed, 9-0. The court reversed the lower courts and ruled that employees do not have to disprove exemptions at the very start of a lawsuit. They only need to allege the basic elements of a prohibited transaction. After that, it is the responsibility of the employer, the plan sponsor, to prove that an exemption applies. The burden flips, and that changes everything. Now, I know the moment I said ERISA, some of you mentally checked out, because it sounds like the kind of legal language that has nothing to do with real life. But stick with me for just a moment, because this is actually the law that is supposed to be the guardian of every dollar you have in your workplace retirement account, and whether it's actually doing its job directly affects how much money you'll have when you retire. ERISA, the Employee Retirement Income Security Act of 1974, is the federal law that governs employer-sponsored retirement plans. It applies to virtually every 401k plan, 403b plan, and pension plan in the country. And one of its most important provisions is a set of rules called the Prohibited Transactions Rules. These rules exist for a simple reason: to prevent the people who manage your retirement plan from using your money to benefit themselves or their business partners at your expense. Under ERISA, plan fiduciaries, the people legally responsible for managing your retirement money, are required to act solely in the interest of plan participants. That means you. They cannot allow your plan to pay excessive fees to service providers. They cannot allow cozy financial relationships between your employer and its Wall Street partners to drain your account. And if they do, ERISA says they can be held legally accountable. The problem is that for years, decades actually, the legal system had essentially made it nearly impossible to enforce these rules. Workers who suspected their employers of mismanaging retirement funds had to jump over an enormous series of legal hurdles before they could even begin presenting evidence. And without access to discovery, the legal process of examining internal documents and financial records, they often couldn't gather the evidence they needed to clear those hurdles in the first place. It was a trap, and the Supreme Court just sprung it open. So what does the Supreme Court's decision actually change in practical terms? Let me break this down in the plainest possible language, because this is the heart of what matters for you. Before this ruling, if you wanted to sue your employer's retirement plan for charging excessive fees or engaging in inappropriate transactions, you didn't just have to allege that something wrong happened, you also had to, right from the start, anticipate and defeat every possible legal defense the employer might use. Imagine being accused of something and, before you even present your own case, you have to disprove every possible justification the other side might raise. Justifications you've never even seen the evidence for. That was the standard workers faced. It was the equivalent of asking someone to prove they didn't commit a crime before anyone could even hear what the crime was. The Supreme Court said in a unanimous voice that this standard was wrong. Writing the opinion for the court, Justice Sonia Sotomayor explained that ERISA's prohibited transaction rules are written in the classic format where the prohibition is stated clearly in one section, and the exemptions, all 21 of them, are listed separately. Under basic legal interpretation, when exemptions are listed separately from a prohibition, the burden of proving an exemption falls on the person claiming the benefit of that exemption, not the person making the initial claim of wrongdoing. What this means in real life is that you, as an employee or retiree, can now bring an ERISA lawsuit by simply alleging the basic facts: that a transaction occurred, that it involved a service provider, and that it may have harmed your retirement plan. After that, it becomes the employer's job to prove that what they did was legal and reasonable. The playing field has been leveled in a meaningful way, and it applies everywhere, in all 50 states, because ERISA is federal law. There is no state in the country where this ruling does not apply. Have you ever wondered why your 401k fees seem so high compared to what you'd pay investing on your own? Have you ever questioned whether the mutual funds inside your plan were chosen because they were the best options or because of financial relationships your employer has with certain fund companies? These are exactly the kinds of questions this ruling now empowers workers to pursue in court. Here's where the story takes a dramatic turn, because while the Supreme Court just handed workers a significant legal protection, there is already a major effort underway in Congress to take it back. And this is something every person watching this video needs to know about. Shortly after the Supreme Court's unanimous decision, a bill called the ERISA Litigation Reform Act, House Resolution 6084, was introduced in Congress. The stated goal of the bill is to amend ERISA to clarify the burden of proof in retirement plan lawsuits and to pause the discovery process while motions to dismiss are being decided. In other words, it would essentially restore the old, harder standard that the Supreme Court just struck down, and it would add a new procedural roadblock that could freeze workers' ability to gather evidence before a case is even allowed to proceed. The bill advanced out of the House Committee on Education and Workforce on a party line vote, Republicans supporting it, Democrats opposing it. One of the Democrats who spoke against it, Representative Bobby Scott of Virginia, was explicit. Last year, the Supreme Court ruled unanimously that plan participants need to only allege that a violation of ERISA's rules occurred to pursue their case. This bill would overturn that unanimous Supreme Court decision and impose additional burdens on workers when seeking to enforce their rights in court. On the other side, supporters of the bill argue that the Supreme Court ruling will unleash a flood of frivolous lawsuits that will ultimately harm the retirement system by making it too expensive and risky for employers to offer retirement plans at all. They argue that excessive litigation drains money from the plans themselves and that workers ultimately suffer when their employers face sky-high legal costs. This is a genuine debate, and reasonable people can disagree on where the right balance lies. But what cannot be disputed is this: the battle over your retirement savings is happening right now in real time in the halls of Congress, and most Americans have no idea it's even occurring. Are you paying attention to what Congress is doing with the laws that protect your retirement? Do you know the name of your congressional representative and whether they voted for or against this legislation? The Supreme Court's ERISA ruling wasn't the only major retirement-related legal development in 2025. Around the same time, a federal appeals court reopened a class action lawsuit against IBM, one of the biggest technology companies in the world, over how it calculates pension payments for retirees. The allegation is stunning in its simplicity and its impact. IBM, according to the workers suing the company, was using outdated mortality tables when calculating how much to pay retirees as pension annuities. Mortality tables are essentially statistical charts that estimate how long people are expected to live. They're used to calculate how much a pension payout should be. Use an outdated table, one that assumes people die younger than they actually do, and the pension payment comes out lower than it should be. The retiree gets less money month after month for the rest of their life. And IBM, if the allegations are proven true, knew exactly what it was doing. What makes this even more alarming is that this isn't just an IBM problem. Similar lawsuits are pending against FedEx and Kellogg, two enormous American companies with massive retiree populations. Legal experts watching these cases say that if courts find that using outdated mortality tables violates ERISA, virtually every pension plan in the country that hasn't recently updated its actuarial assumptions could be exposed to similar legal action. That represents potentially millions of retirees who may have been receiving less than they're legally owed for years. Does your employer offer a pension? Do you know when the last time the pension plan's actuarial tables were updated? Most people have never even thought to ask that question. But given what's now happening in federal courts across the country, it's a question that could be worth asking. All of this legal activity in the Supreme Court and federal appeals courts is important, but it only helps you if you actually know your rights and take the steps to protect yourself. So, let me walk you through what every person watching this video should do right now. The first thing you need to do is find out what fees you're paying inside your retirement plan. Every employer-sponsored retirement plan is required by law to send participants a fee disclosure document. It's called a 404A5 disclosure, and it should arrive once a year. If you've been throwing this document away without reading it, stop. This document tells you exactly how much you're paying in administrative fees and investment fees. If your total annual fees are above 1% of your account balance, you need to start asking questions. Because with index funds and low-cost investment options widely available, paying more than 1% is often difficult to justify. The second thing you should do is compare your plan's investment options to what's available outside the plan. If your 401k only offers high-fee mutual funds when equivalent low-cost index funds are available, that is the kind of arrangement the Supreme Court's ruling now makes more challengeable. You may want to speak with an independent financial advisor, not one connected to your employer or your plan provider, to get an objective assessment of whether your plan is competitive. Third, if you are a retiree receiving a pension annuity, find out what mortality tables were used to calculate your payments. This may require a formal request to your former employer's Human Resources or Benefits Department. If the tables being used are more than 5 to 10 years old, given the wave of litigation now moving through the courts, this is something worth having an attorney or financial advisor look at. And fourth, stay informed. The ERISA Litigation Reform Act is moving through Congress right now. Whether it passes and in what form will determine how easy or hard it is for workers and retirees to enforce their rights under federal law in the years ahead. This is a critical moment to know what your elected representatives stand for and to make your voice heard. The Supreme Court speaking with one unanimous voice, 9-0, is rare. It happens when an issue is so clear, so fundamental, so important that justices who disagree on almost everything else find themselves standing on exactly the same side. And this court, this divided, ideologically fractured court, stood together unanimously to say that American workers deserve a fair chance to protect their retirement savings in a court of law. That means something. That matters. Your retirement is not a line item on a corporate balance sheet. It is your future. It is your security. It is decades of work, sacrifice, and deferred gratification that you are counting on to carry you through the final chapters of your life. You deserve to know what's happening inside the plan that holds it. You deserve to have legal recourse when those plans are mismanaged. And now, more than ever before, you have that. So here is my question for you. The one I'd love you to answer in the comments right now. Did you know this Supreme Court ruling had happened before watching this video? Because I'm guessing the answer for most of you is no. And if that's true, think about how many other people in your life have no idea either. Share this video. Let's make sure the people who need this information actually get it. Please subscribe if you haven't already, like this video if it gave you value, and check out our next video for even more on how to protect what you've worked so hard to build.